Montana on the move. That was used in the PSA. I don't know where it came from, but my sense is, quite frankly, again, it's irrelevant. And what Lynette Lark said in requesting or not requesting the PSA, and when she requested that, yes, I think it is irrelevant. What this case really comes down to is the basic facts. The governor, after he filed for re-election, produced a radio PSA, and that radio PSA was distributed and apparently ran.
And I don't think there's no question of fact that it did run.
Okay, and can't this tribunal make a decision of law as to whether the governor violated the law or did not violate the law on those facts alone?
I believe you should.
Do you think we should? That this tribunal should?
I believe you should. I believe you should. I believe that counsel should withdraw his argument that it would have a chilling effect on government.
Well, I wouldn't consider his argument about chilling effect. I can care less about the chilling effect. It's not up to me. What we're saying is the legislature wrote the law. I'm leaving up to you guys to argue what the legislature intended as to what the law means. I quite frankly don't know what that law means. I have to focus upon that. But what I'm hearing you both say is there really aren't any outstanding factual issues in this matter that need further exploration by either party. We've got the governor and his staff producing a PSA at the governor's office. It used his voice and his name. It was distributed to radio stations, a number of radio stations. How many, quite frankly, I think is irrelevant. And in air. Correct. It seems to me we've got all the facts that we need to make a ruling as to whether the governor violated the law or not.
I'm with you.
Okay. That's where I'm at. And as a consequence, I mean, my sense is there's no reason for further discovery of this case. There's no reason for any public hearing on this case in terms of hearing more witnesses testify or gathering more information. That what is actually needed is for me to look at that very brief factual summary and make a determination. Did he violate the intent of the legislature or did he not?
Can I make a little
sure.
bit of a record, Your Honor? Because I don't want to be reading your determination and then see in there that, as the governor alleged, and it was uncontested, that this would such a construction would
there wouldn't be any justification. I mean, as far as that is concerned, is that
so I think
justification is irrelevant.
And
what he wanted, I don't care. If the law says, I mean, I look at this statute to some extent, the law says that you can't go 45 miles an hour in a 30-mile-an-hour zone. If he was going 45 miles an hour in a 30-mile-an-hour zone, he violated the law. And I don't care what he thought, what he intended, what somebody else told him, what was going through his head. It seems to me that the sole question is, did he violate the law? Was he going over the speed limit? And we don't need any more facts to determine that.
I agree. And to use your hypothetical, which was so eloquently stated, the argument here is I need to go 45 because it's important to the people.
Right. No, that's off the board. You can't say to the cop, well, Mr. Police Officer, my wife had a flat tire last night. Eventually, she got hold of me and I was summoned to where the flat tire was, and by that time she managed to get it fixed herself. Congratulations to her. But I didn't win any points. But if I had been speeding and I had told the cop, look, my wife had a flat tire and I was speeding to try to get to my wife to help her or something, my sense is I still violated the law. If I'm speeding going 45 in a 30 mile an hour zone, I'm still in violation of the law. I can maybe talk to the judge about that, but there is no, the law doesn't say, well, you could go 45 mile in a 30 mile an hour zone if you come up with a good excuse.
I couldn't agree.
We all try to do that. I've done it a couple of times, but very unsuccessfully. I still got the ticket, and the judge still imposed the fine. But that's what I think we got here, is based on these very limited facts that both counsel agreed to. This case is ripe for decision, and that decision can be made as to whether the governor, under these facts, regardless of any, his intent, his motive, whether he was, commanded, requested by the radio station, doesn't make any difference. If he was going 40 miles an hour in a 30 mile an hour zone, he violated the law. Doesn't make any difference what the radio station was asking him to do, what his staff was asking him to do, whether he wore makeup or not, whether he used throat spray or not. Doesn't make any difference.
I'm with you.
Okay.
Thank you.
Okay. Mr. Malloy, you certainly have an opportunity for rebuttal. You can use that opportunity in any way you feel fit, but I would like to get from you the sense of whether you believe this case is in fact now ready for a decision based on that very narrow factual record that I outlined. Forgetting any kind of arguments of justification or the better good of mankind, if the governor, under this law, is prohibited. Now we're assuming that that's what the law says, and we're assuming the ultimate legal question of the law. If the law says the governor is precluded, once he files for re-election, from making PSAs, distributing PSAs, and if those PSAs run, he violates the law. Can I, under those facts, make a ruling as to whether or not this governor, in fact, violated the laws? Is that what the legislature intended? Or did the legislature intend your reading that the governor would only violate the law is if he were paying using state funds to run the ads? I mean, I understand we have a difference in interpretation of the law. Is not the tribunal ready to make a determination of the law, but we don't need any more facts?
Well, that's what I've been arguing from the beginning, Your Honor. There's nothing in either party's theory of this case that depends on whether or not Ron Zeller talked to Lynette on the 23rd of February or she talked to Sarah on the 6th of March. We have conceded everything that you need to decide factually. We've set the factual settings and you can decide this case based on our different views as to the statutory meaning of this section.